Hey guys, good morning or afternoon, depending on where you're at. I'll tell you the objective of what we're going to do, and then we'll do it. So let me make this a little bigger. Looking at the Sarah Boone case, in her last letter, she had complained about her expert prison break investigators not being able to visit her in jail. And of course, we know she's got scheduled a request for another forensic psychologist to visit her or to be in her case, and that hasn't been dealt with by the court yet. And of course, she's constantly complaining about the level of attention she thinks she's not receiving in her case. You know, what the actual facts are on that, who knows? She's not the most reliable person for what is actually happening to her and whose fault it is. But what I did do was go back to the beginning of the case and look at all the expert activity and some other stuff too, because there's a lot of it. Because one point that had been made was, well, maybe prison break investigators doesn't really have anything to do with this case. That's why the lawyer wasn't talking to them. And I saw that he had requested them on the case, but then found out they'd also been requested on the case earlier by a prior attorney. So let's go all the way back to the origin story of this case and take a look at it. The very first activity, and it's always possible I miss something, and I haven't read this, so we'll see it together for the first time, but the first activity in her case for an expert was in May of 2020, right? So this has been going on for a long time, when her attorney at that point made a motion for a crime scene forensic expert to assist the defendant, preparation of the defense. She's charged with second-degree murder. She doesn't have any money. And let's see what they were going to do. They wanted to retain the services of J.D. Thomas of Forensic Consulting Services out of Florida, and pay him $150 an hour, up to $7,500, to do crime scene analysis, right? So this is a request by the defense. This is not granting it yet, but I'm just going to work through this chronologically. So that was requested there. Let's see, we got Steve Gosney in the chat. So let me make sure that everybody knows, if he tells you something that amplifies, corrects, or clarifies anything I say, take what he says as correct, because he's the expert on this, and I'm a mere tourist on this case for sure, and this state. But this was a lot. I had to trim it down a little bit. There's over 100 pages of expert activity. So the defense quickly asked for this crime scene expert, and then the defense asked for an electronic evidence expert. And this was for cell phone tower analysis, saying that the state of Florida had indicated they intended to rely on cell phone tower data to establish her presence at the crime scene. And analysis of the reliability of that is critical to the defendant's case and his right to due process. Maybe they're using a form there because it's a her. But regardless, they're saying that we want to do this, and also introduce evidence that's been forensically extracted from the defendant's cell phone. Now, that's important. And I don't think she contended ever that she wasn't there that night, but there were the videos on the phone. And I'm sure that the defense wanted to have a look at that. So they asked for this guy to be appointed. He normally charges $350 an hour, and agreed to accept $200 an hour because he's being paid out of state funds or whatever agency they use down there. So there can be a contention on how much you get paid by the hour, because they have rates that they agree to pay and others that they dispute. So we've got two defense requests here, if you're keeping score, made early in the case. I mean, almost right away, I think. And then here comes the judge saying, yes, the order granting defendant's motion for payment of cost for the forensic crime scene expert. And okay, so that's the J.D. Thomas, nothing on the cell phone yet. So she got an expert early in, and here's some email stuff to back that up. Let's see. And then an amended motion to appoint the electronic evidence person. So this was the person who they said they wanted to talk on the cell phone analysis and data extraction from the phone. And I don't know that this changed in any material way. It doesn't appear to it, except JAC gave a no response email. Maybe that's good, because they're opposing the current forensic psychologist that's being requested for the case, as you'll see later. I'm not going to read all these emails. We're really just sticking to what has happened on this case. So we got two experts requested. The crime scene person is approved. And then they come early in this case. When is this? This is June of that year for a forensic psychologist. The undersigned is a privately retained and request assistance of a forensic psychologist to perform an evaluation of the defendant. $200 an hour, $7,500. So now there's 3 expert requests: the cell phone, the crime scene, and a forensic psychologist. And I'm not sure exactly what that person was going to do there. We do know at this point, of course, that one of the things Sarah wants to do is rely on self-defense and battered spouse/partner syndrome to establish an element of that. Well, I mean, I don't buy it in her case, but that's what this person could have been doing even early in the case. But it could also be other things too, because there can be mitigation and intent and what was going on and all that. And then they amend this motion. I'm not going to do any comparison here because trust me, there's a lot of documents. But same thing though, they're $200 an hour, which is not unreasonable, I think, and $7,500 cap. Let's move through that, blah, blah, blah. The Justice Administrative Commission, that's who pays for these experts when it is an indigent defendant who needs them and the court approves it. So here we go. So the order authorizes the electronic expert, evidence expert. So this is the person for the cell phone. And let's see what she gets here. Wow. $20,000 is allocated towards the person who was requested by the defense to analyze the cell phone electronic data. So now she's got a crime scene expert on board and she's got a cell phone expert on board. And, in terms of fairness of all this, the state has the experts paid for by the state on their side, and she's indigent. So it makes sense to have experts on the other side who can look at this for her. Proposed order granting the motion to appoint the forensic psychologist. So she's got 2 out of the 3 so far. And even though it says proposed order, this one is signed by the judge. So I guess that became an order. $7,500 for that. So she's got 3 experts in the case as of August 2020. Let me put this up here because I think this is a great point by Steve. Experts can assist the defense attorney to understand if there are any issues. Lawyers are not psychologists, and it's a complex subject. Often the expert just assists the defense in questions. So that's a fantastic point. Let me bring that, say, over to the Koberger case, where you see some of the DNA experts that the defense has revealed in terms of affidavits and stuff are there to some degree to help the defense attorneys just understand the complexity of DNA and what issues there can be with it and how to explore those. Because Steve makes a great point. I mean, an attorney's not necessarily an expert in everything. So aside from what would occur to me immediately, since I'm not a criminal defense attorney, is you hire the psychologist to just do this defense. Steve makes the point, which you can see active in other cases, that these experts just help the attorney frame the case, understand what issues they might not come to their mind. So that's a really good point. So she's 3 for 3 here. Lawyers having trouble understanding cell phone data. And yeah, I have trouble figuring out how to turn it on and off. So luckily, there aren't any defendants whose freedom is resting on my ability to rebut the state's case on electronic evidence for cell phones. I'm almost at the phase where I had to have a phone with the big numbers on it. All right, so we're 3 for 3 at this point, and let's see what happens next. And it's pretty good, right? She's got a crime scene expert, she's got an electronic evidence expert, and she's got a psychologist. Now they've got a motion to incur costs for a private investigator. Let's see who she wants. They're asking for $40 an hour, which even in 2020 is like, wow, that's low. And $5,000 is what they want. I'm looking to see if I missed the name here. Not sure that I did. But I know we're going to see it in a minute. I know this keeps coming up. Here we go. Order granting the motion for incurring costs for a private investigator. She's broke, and so they agree to pay. They made it $4,000, so 100 hours at $40 an hour. I think the names come up on this. A lot of this is struck out for some reason. I guess there's some more money and stuff on that. All right. So anyway, so now she's got 4 assistants for the defense. All right. So for anybody keeping track at home, that's good. I think that's, all right. And then it seemed to happen in a fairly rapid manner. Of course, We all know that the criminal justice system, like other institutions, suffered a lot of delay during the response to the pandemic. And a lot of criminal defendants cases were heavily delayed. And, that could work to the good if somebody is nasty and guilty, but also if you're innocent, it's bad. And it's never really good, I think, for the system to have huge delays in it. And her case has been going on for quite a while. And if Steve's still listening, we talked a little bit before the stream started on Eric's channel about Steve being involved in an appeal where the state's taxing cost against the defendant who's incarcerated. I hope that comes up as a topic sometime. And if I missed the stream, I'd like to see it, because that's an interesting issue of fairness, I think, and what's excessive. All right, so now we want additional cost for a crime scene expert. We're into February of 2021. Of course, there are issues here. The court previously authorized 50 hours, and those have been exhausted. The JAC does not oppose this. They want an additional 50 hours. Okay. So we've got the experts. They're working. Some of the money's spent, and they want more money. Order granting defendant's motion to incur additional costs for crime scene expert. So they got that. They got the additional money. So right now, at least, when she had this first attorney, it seemed like things are moving along pretty good for at least this part of it. Because mixed into the docket are a lot of other activity, subpoenas and things like that. So it wasn't just expert stuff, but that's what I called for this. Now they want a mitigation specialist. And they consulted with Katie Rain from Prison Break Investigations. Remember, they're the ones who, I think that's the same outfit that was supporting Sarah in her most recent letter saying they can't get into prison to see her. And this person holds a JD and is a licensed investigator, a BA in psychology, and will work on indigent cases, capital cases, for $40 an hour. So that's a very generous rate to the state. I mean, that's crazy low for this. He needs 200 hours of this, he says, to help Sarah, $40 an hour, and some records costs and some travel costs. And they just want $5,000 for this. And a mitigation specialist is an interesting person because, they can go around and find circumstances that could mitigate the conduct that the defendant did and help the defense attorneys frame that, as well as go find information that could support it. And we know Sarah wants to say that she was a battered spouse/partner. So whether they've developed that as so far in this case at this point, I don't know. July of 2021, motion to appoint a forensic pathologist. So now we're expert 5 that I'm trying to juggle in my mind early in the morning. They want to appoint Dr. Edward Willey, forensic pathologist. And that makes sense too, because how the death occurred is certainly relevant to this case. He wants $300 an hour. Initial cap of $7,500. All right, let's see if they get that. I would think that they do. Proposed order, and the judge has signed it. So yeah, so now she's got a forensic pathologist. So I think she has five experts. So look at this. Steve says, a mitigation expert in a non-death penalty case is unusual. And that's interesting because obviously she's second degree here, with the state saying that her conduct was reckless. And that was one of the things that was bad for her in her interview, was she kept saying, I didn't intend it. And that didn't really help her because they were looking at reckless. So I think she thought she was trying to talk her way out of trouble, but it didn't keep her from getting the second degree murder charge. But that's interesting for the mitigation expert in non-death penalty cases. Unusual because this prison break people are the same ones that she's writing about now. And it'd be interesting to see if she got it here. All right. And of course, and Steve knows more about it than I do, but say in a death penalty case, typically speaking, if you go through this guilt phase, then you go through the penalty phase, the state has to prove an aggravating factor, at least one, I think everywhere. And then the defense can show mitigating factors, and then the jury can weigh whether the aggravating factor was proved, and if it was, whether the mitigating factor, how that weighs together. So you definitely need a mitigation stance as a defense, I would think, unless you just want to ride the lightning. And a mitigation expert certainly makes sense there. So it's interesting to see that it's rare in these lesser cases, but I guess that makes sense as I'm thinking about it. All right, so we got this forensic pathologist, and they want more cost for a private investigator, not pro-tunc. It just means going back in time. Prison Break Investigations has exhausted its funds, so they got this. Did I miss where they got that? Maybe I did. I'm not going to remember all those people. You'll have to help me. But anyway, Prison Break Investigations exhausted funds and wants $6,000 more for 150 hours. Okay. So you can see Prison Break Investigations is definitely active in this case, or certainly involved in it. So this is interesting. Steve says, when the state seeks the death penalty, defense immediately retains a very expensive mitigation expert at a big cost. Yeah, some of the costs in this case are like, I can't believe these rates. But, we talk frequently about death penalty stuff, especially when Steve's on a panel, on Eric's panel when I'm there, because it's an interesting topic, and because also whether you're for it or against it, the system is just a gigantic mess. Then on top of that, there are good reasons to debate whether you should have the penalty or not, and good reasons to discuss how this country handles that penalty. But certainly having the defense having the ability to have an effective ability to present mitigating circumstances is critical to the process for or against the death penalty. So, how good the defense is, it just depends on where you are and all that stuff, I think. All right, so let's... Prison Break Investigator, I think, if I'm remembering right on this and still working forward, for the purposes of this case, was a mitigation expert. Now, I don't know Steve's opinion on this or if he wants to give one, but I feel like Prison Break Investigators is an interesting name for a company that's going to work for the defense. I just imagine a prosecutor making something out of that name. Like a good name might be like, my client is actually innocent, or uncovering evidence the state tried to hide LLC rather than Prison Break. So, I mean, it's cool if I did it, like OJ, and there's a firm called Prison Break. I'm liking that. But if I'm innocent, I might not like the connotation of that name. That's just me. I'm no marketing guru. I have to say, I can't really forget the name of the firm, even if I don't know anything about them. So there is that. Motion to incur costs for travel outside the state of Florida for the private investigator. And, I don't know what all they needed to do, but witnesses and stuff live in different places. So they want to go outside Florida to Philadelphia and Massachusetts to investigate and interview witnesses for the defense. And they need to stay at a hotel and fly up there. That makes sense. Fairfield Inn, blah, blah, blah. So the order grants the defendant's motion to incur costs for private investigator travel outside the state of Florida. So it's an interesting process, isn't it? And if you're indigent, you need to spend this money. There's no just like general budget or whatever. You look at all the activity that has to go on in the file to get authorization for these costs. But so far, it seems that the judges involved in the case, and they have changed as this case has moved on, have been willing to support the defense generally for what they want, which is good. Now, a forensic consultant, amended motion. So an amended motion, I guess that's perhaps the same person that they dealt with before. It looks like they're just debating rates and things like that. Contrary to counsel's motion, JC's paid $300 an hour. Paramedical nursing time. Anyway, I don't think that's a new expert. That's just talking about how much they're going to pay the person. Now we're at December 2021. The JAC's response to the motion to appoint a domestic violence psychologist expert. That's at $7,500, $200 an hour. And they object to pay compensation at rate of established rates, which that's what they're also saying in this current dilemma that the defense is having, that her attorney has noticed for hearing in September to have the judge decide, are we going to pay this rate or not? That's the $400 an hour person. All right, let's roll through JAC. Here's the motion to appoint domestic violence psychologist expert to assist the defense. Maybe I got those out of order. Yeah. And my career has been more on the civil side. And I will say that, I had some involvement in the criminal justice system working with the state and profiling before I got a law license. And then I represented a police department. So I was involved in it more from that angle and not as a criminal defense. So I've seen a lot of it. I'm no expert in it. And then it's all state specific, but it's also, as you're pointing out here, practice specific. So I can understand what they're talking about, but it doesn't mean I always know all the details and things, and I have to look up a lot of things. And Steve says that it seems like this lawyer's doing a bang up job getting the experts lined up. Yeah, it seemed that way to me too. Now, of course, she's been through a lot of attorneys, and I didn't end up putting that in this video because this part is so long, but she's been through 6. And this first attorney who had all this activity, she ended up writing a letter saying she was betrayed by him, stuff like that. So I might do a different video where I talk about how the attorneys came and went out of the case, because while some of them appeared to have maybe a conflict with the client, some of them were conflicts of interest for other reasons. It's not like her behavior could have caused the switchover of all these attorneys. Some of them were from appointed attorneys who had conflicts due to other witnesses and things. So we'll go through that at some point. But this first guy he was way active. If you scan the docket, he was not just doing this expert stuff. He was doing all kinds of subpoenas and motions and lots of stuff. And why he ended up out of the case, I don't remember. But you're not going to get the whole story from what's on the docket, but there is some information there from what he filed and then from what she wrote. If a judge denies an expert, does that enable the defense to claim on appeal that it was an unfair trial? I mean, my sense of that is it just depends, right? It depends on what the expert is. And it's not an unlimited budget and blank check for defense, to put it mildly. So I think it all depends on the case and the situation and all that. And for example, she's asking now for another psychologist to be appointed in her case, and yet she has had others appointed. So it's like, how much money does the state have to spend to support her case? And there's going to be a motion hearing on that in September, and I guess we'll find out what the judge thinks about that. Motion to appoint domestic violence psychologist expert to assist the defense. So this may be trying to move up this situation about self-defense, because my understanding of the law in Florida is, and other jurisdictions can treat it differently. So self-defense there, if you have battered spouse syndrome, battered partner, or whatever you want to call it as it becomes more modern, that's used to establish that it was that your fear of imminent death or serious bodily harm was reasonable at that point, even if you weren't being attacked by the person. It's not some separate thing. And it's not even really in that context mitigation. It's actually to support a full defense of the claim, self-defense. As if the person were pointing a gun at you right away, so you shot them to defend yourself. They're not pointing the gun at you, but because of the syndrome you have, or the circumstances you experienced, you still reasonably felt like that you were in imminent danger of death or serious bodily harm. And I think that's what she would like to do. We talked about whether, everybody's opinion on whether that fits the facts, not the facts that I've seen. But I do believe in that defense. I just don't think it applies here from what I saw. So they want to appoint Dr. Charles Heller, forensic psychologist, and no response from JC. He's had $200 an hour before, and they're looking for $7,500. That seems to be a magic number, maybe there. And proposed order granting this person, and that's signed. So she had a forensic psychologist and then also this domestic violence psychologist. Interesting. See, I didn't know there were so many of these people appointed in this case. I just didn't, because I hadn't read the docket. I'm going to look at a couple things here. So here's somebody asking Steve Gosney, do you feel Sarah Boone would be found not guilty along the lines of how Daniel Radlick was also found not guilty? So if Steve does decide to answer that, I will certainly post his answer up there. Her first attorney yeeted because Sarah Shakespeare wanted to testify and say non-intentional a million times. Yeah, I'm going to go back, and I know she wrote a letter on it, and he had a motion. there are issues for attorneys when you try to withdraw out of a case. It's not like you can just suddenly rat out your client in a public document about how terrible they are and they're a liar and they're actually guilty and stuff. You can't do that. So I don't think there's going to be the full story from the attorney in the file, regardless of what her letter says. And then you have to take her letter with a grain of salt. But I will say that it appears from the docket, this attorney, when he got on the case, he got on the case. And then with as much fervor as he got on it, apparently he decided to get off of it. All right, so she's got, I've lost count of the experts out there. There's like 6 or 7 experts now on this case, and a considerable amount of money being applied to the case by the state. Let's see, corrected order, so that's okay. That's just correcting how much money they're going to pay for the activities. Additional cost for forensic experts is ordered by the court. J.D. Thomas. So looks like they're giving a little bit more, some more bucks there. Motion for authorization to incur additional costs for forensic expert funds. So yeah, that's for the J.D. Thomas. So as the expert moves through the case and they exhaust the cap, they come back to the judge and say, give us some more money, and the judge can decide if that's fair, reasonable or not, and do it. And apparently they generally have been doing it. Then they want some transcripts. Yeah, of course, that makes sense. And one of the other things I'm going to comment on at the end is I don't see that Sarah ever had like an author hearing or whatever, because she's held without bond. That's all I saw in the docket. I didn't look at it too closely, but for certain kinds of crimes, a lot of states have a scenario where you can be held without bond if the proof is evident or the presumption's great. You can have heard that in the Richard Allen case. It's similar in Florida. That's the box that was checked off I saw when she was taken into custody. But you can challenge that, as Courtney Clenny did, and try and get some kind of pretrial release. And I didn't see that in Sarah's case that did happen. So I don't think there's been a lot of bond activity or any bond activity that I saw. I'll look at it more carefully. All right, so they got an order granting their motion to travel for cost for travel. $5,000. They want the computer forensic expert to bring into Orange County Jail the expert's computer, right? So the expert wants to be able to take his computer into the jail. Orange County jail policy requires any electronic files to be brought in on a USB flash drive and viewed on the jail's computer. But the Dell Latitude 6530 provided by the jail has the operating system locked down to prevent installation of any software. And they need to be able to do that. Celebrite, which you see that come up in a lot of cases, that software. And the report attached pictures in Apple's proprietary format. Can't be viewed on the jail's janky computer without additional software. They're never going to get that thing to run. If I were the judge, I would be completely sympathetic to the expert here. And they do note that this dude is a former law enforcement officer and a member of the Florida State Bar, and he's not sneaking in a computer to help the defendant. He's just trying to do his job, I think, is the implication there. Then they amend the motion for whatever reason. Motion to incur costs for private investigator. Now here it says the defendant is indigent and been charged with capital murder, and I don't think that's correct. But sometimes you have forms, you try to adapt them for your client, you miss things, and you just get on with life. At the big firm where I worked at, they would crucify you for a typographical error, but on the street and street lawyering, sometimes it happens. And they want up to $10,000 for this PI. Oh, wait, you know what? Let me back up here a little bit. So we went from April of 2022 all the way to January of 2023. And the reason I'm backing up on that is because this motion is filed by her current attorney. I think this is the first one that we are seeing. Yeah, by her new current attorney, the guy still on the case. And here he asking for a cost for private investigator. And $10,000. And they want, this is a new firm, I think, right? Aran and Associates LLC, $40 an hour. This motion filed in January 2023. that's an incredible rate to have anybody do anything, especially somebody who's having to have a professional license, right? I mean, that's just amazingly low rate. I understand that. So the order authorizing the defense to incur costs for a private investigator, and let me make sure this is signed. It is signed. So the court says, yep, new attorney, and this is the current attorney. You can spend up to $10,000 for this person at $40 an hour. They got to be properly licensed. They only be compensated for doing this, that, or the other, and all of that. So the current attorney did get additional money for a private investigator, and apparently a different private investigator. And then he made this motion here, which is, I think, still going on, which is motion to incur costs for a mitigation expert. And now it says she's been charged with second-degree murder, and they want this mitigation expert $10,000. And see, that this guy said, I want prison break investigators, right? So that's the same firm that was involved earlier, and he wants $10,000. And he filed that in February of this year. So it is interesting what they're doing, and maybe it isn't strictly mitigation. It's just general help of the case in addition to mitigation. And then we got the response in July of this year from JAC saying, hey, that's too much money for the, hang on a second. Yeah, so in between this, he filed a motion that is under seal for another forensic psychologist. And you can't see it because it's under seal. So the new attorney's filed for 3 more experts, right? 3 additional experts. And this most recent filing he made is for a forensic psychologist. And if you remember, he was in court saying, I can't find anybody who will come testify for the rates. So I don't know what happened to all these experts that were in the case before. My theory was that they didn't get what they wanted from these experts in terms of supporting this domestic violence self-defense claim of battered spouse. I don't know. Maybe the people moved or they don't want to testify anymore or whatever. But he has somebody now who he wants at $400 an hour, and then JAC says that's too much. So we went over that. And then her attorney calendared that for September. And go back up here to the street lawyering. I know that was, yeah. So an early example of street lawyering for me was when I was not too long out of law school and working at a gigantic firm, this plaintiff's lawyer. We went to court and I had a motion to dismiss his infliction of emotional distress claims. And I thought I was right on the law and wrote a really good brief and stuff like that. But in North Carolina, the judges don't have much, or they didn't back then, have much time to read that stuff unless it's super important. So they're kind of listening to you at the actual motion, make your argument. And this guy basically said, Judge, let's just do the right thing here and split it. And I'll agree that you can drop I guess it was the intentional infliction, to just keep the negligent. And I tried to argue to the judge, but Judge, neither one of them are supported. And the judge did say to me, he's given you one of them. What do you want? And this was a 12B6 motion to dismiss. And so I won one, lost the other. And after we were over, the guy came over grinning. He goes, that's street lawyering, baby. So he and I had a lot of battles together, and I learned a lot from him when I was on defense then, as he was a plaintiff's lawyer. So I actually appreciated having cases against the guy. He's just a pleasant guy to work against, but it was funny. All right, so that is the expert drama there. And I did, I think, mention earlier that I think she's sitting in jail with no bond because she was put there because that's the level of crime where you can do it, and you can request an Arthur hearing to try and get out of jail on pretrial release. And I don't think that has happened in her case. So what I didn't do was go through all of her attorneys and why they came and left, because I thought this would take a long time. It actually went a little faster than I thought. There's over 100 pages of this expert stuff. So if you wonder about her case, then you do have to see that her attorneys through the process of the case have achieved like 7, 8, 9 experts involved in her case so far. So there has been a lot of money and a lot of experts involved. But they want this new one to come in and finally tee this thing up. I think this trial doesn't happen until next year. So I see Steve has come back and he put this answer in. I said I would put it up, and here it is. So Steve thinks she'll be found guilty. I kind of find it hard to see another scenario too. I mean, I get that she wants to say the domestic violence, battered spouse, but she gave an interview to the police where she said they were playing a game and she went upstairs and went to sleep. It wasn't intentional. She didn't mention that she was afraid of him or in fear or anything like that. Now she could say, but I was terrified to tell the police the truth. And maybe that's what she will say. But I think in her case, the interview she gave to the police kind of tracked with the facts of the case. In other words, she was somewhat loaded and he got in the suitcase and she ended up going upstairs and going to sleep. Of course, she left out the part about taunting him as he said he was dying, which I, again, feel like if you're in fear of imminent death or harm, you're not just going to sit there taunting the person to make them more angry and then go to sleep. Because if he does get out of the suitcase, he's going to be doubly mad, like you would flee the place or whatever. You know, to me, the battered spouse thing is more like the guy's like, I will kill you wherever you go. You can't get away from me. And has demonstrated reasons to believe that. And to get shot in the middle of the night because the person feels trapped. That's when you would consider a defense like that and see whether it's reasonable or not. That's just my opinion. So I don't see her sliding out of this. Now, I do get the question sometimes of, well, why doesn't she just plead guilty to manslaughter? And I think the obvious answer to that, to me, not knowing the situation, is that she probably hasn't been offered that. I don't think the state has offered that to her. Now, they may have had plea negotiations in the background, but I don't know what they would be. Now, given that she's been in jail for almost 4 years, at some point, time served becomes an element if they do offer her a plea deal. But I don't know if they have or they have not. It's not up to her. She can't just say, well, I'll just plead guilty to manslaughter, get it. The state has to agree to it. And if the state wants to offer her plea bargain, she'd have to agree to that. It's an agreement. It's a bargain. So, you know, it requires the consent of both sides. So I don't know that that's occurred. And if you read her letters, she really feels like she didn't do wrong. And I think that it's consistent with her interview with the police, that she's not seeing her culpability in this. But pragmatically, if they did offer some kind of manslaughter thing and it came close to the amount of time that she's already been in prison, she'd kind of be crazy not to take it because she's facing a substantial penalty if she goes to trial on this. So must outlaw assault suitcases immediately. Yeah, I'm fortunate at this point in my life that I'm too big and too inflexible for anybody to get me to get into a suitcase unless I have already been killed. My wife is looking at me from across the room now. So if she had that plan to get rid of me, she's going to have to come up with another one. I'm going to have to be taken out before I get in the suitcase and not after it. So Sarah's kind of a popular case because of all the letters she writes and just the crazy circumstances of the case. But I think this was eye-opening for me to see the level of experts already appointed to this case. And then the next thing I'll look at on it when I get a chance is how the attorneys have moved through the case, because I think that is unusual to have 6 attorneys. And this current attorney, his name's up there. I'm going to scroll this and I need to keep showing his phone number or whatever. But, you know, he made a motion to withdraw. And then there's a note in the court record that says the defendant did not request him to withdraw and did not want to get rid of the lawyer at the hearing that they actually had. So somehow maybe the judge spoke with them and brokered some kind of deal for him to stay on the case, that, well, you'll agree to call her by this date and have this meeting. And she goes, well, if he'll do that, that's fine. And then the lawyer stays on the case. But she's perpetually aggrieved at the attention she gets from the attorneys. And you have to filter that through how much she lies about everything and misperceives things. On the other hand, you know, a defendant is entitled to competent representation. So you do have to pay attention to it. If someone doesn't work on her case at all, that can be ineffective assistance of counsel, but also it's just bad, right? I'm not saying that's what's happened with this lawyer, but I am saying that just because she did a terrible thing doesn't mean that she doesn't deserve a defense, because once you go down that road, then nobody gets a good defense. So that's what I think about that. Let's see. So Steve says, this is a lot of experts for a non-death case. Well, that's kind of what I thought too. I mean, I'm not an expert on it, but I thought, wow, because when they brought the current motion to have this forensic psychologist, that's when JAC filed their motion to fight against it, saying we've already spent this much money on somebody like this. So then I said, well, I better go back to the beginning of the docket and see just how many experts are in this case. I mean, if Sarah's just expert shopping because she wants to finally find a psychologist who will say she's a battered spouse, you know, the state doesn't have to just spend infinite money on that. And then when I thought, well, I'll just download these and go through them in a stream, and it got over 100 pages, I'm like, well, there's going to be a lot of experts. And I didn't see this until we all saw it together, but this is This is a load of experts who have provided assistance in this case so far, and it's all in the file, I would think. So her attorney wants additional experts, and some of them on the same topics that other experts were already engaged for, and that's the JAC's primary opposition to this current person in addition to the rate. Steve says he knows of him, and all I'll say on that is I know of him from Googling and what I found on that. So I don't want to say too much about that, because his work on this case is whatever his work on this case is, and I think he's in a trial right now and stuff like that, and he has filed for additional experts and things, and he's the one been asking for a continuance to try and find this new expert. So maybe he does need somebody to help him with this case. Expert shopping. Well, that's what I wonder. If you've got how many, they had a domestic violence expert, they had another forensic psychologist, maybe another one on top of that. And then here comes a third or fourth person in that area. It suggests that to me. It does suggest that to me. Thanks to Marsha Lynn for supporting the channel, and Susan as well. I appreciate that, guys. And, I'll say, from the civil side, every case that I worked on had experts in it. You always can have an expert on both sides. That's the fascinating thing about experts. In theory, they're supposed to be able to just dispassionately look at something and give you their expert opinion. So how come their opinions are always the opposite on each side of the case? And then people say, well, it's because of whoever cuts their check. So I'm not going to dispute that entirely, but one of the things you would do is you'd have an oral discussion with the expert about your case. And then if it's not leaning how you want, then that's a consulting expert who's just helping you. You don't disclose it in a civil case, and you get your testifying expert who has the opinion that is going to support what you want. And the criminal may be a little different than that. But certainly if you watch criminal cases, you will see the state put on a doctor who says one thing, then the defense puts on the doctor who says something else. And sometimes they try to professionally respect each other to say, well, the doctor didn't have access to this piece of information I did, so that's why I'm different, or the conclusions can just be different. And then sometimes they just flat out contradict each other. And here's a comment that with a bunch of dollar symbols, and that can be an element of that. Steve says he's done many appeals from Judge Wooten's court, which is interesting. I feel like this guy here has, this judge and the judges before him have been pretty permissive on giving the defense what they want for experts, and he certainly didn't reject it out of hand here. The JAC has opposed it, and then he will hear this in September. And I watch it sometimes when I can to see what's going on there. And he's been responsive, at least to making sure Sarah was in court for the last hearing or two, I think, based on her letters to the judge, where in one of the letters she accused the judge of sharing in the lucrative YouTube revenue about this case. And then in her last letter, she lauded his fairness and impartiality. Forensic psychologist will tell the court her sadism is readily evident. I feel like not the one they hire. That's what I think. Good to have firsthand insight from Steve. Absolutely. There is an old saying here that a good lawyer knows the law, but a great lawyer knows the judge. And there is nothing like local knowledge of how things work and what judges are sensitive to, what issues that resonate with them and what don't, and all of that. Sometimes out-of-town lawyers can come in and win, of course, because they're talented and all that stuff. But if you do, it would be good to have a local counsel who can really give you the score. I think I mentioned the most famous example of that I was involved in was when Johnny Cochran came to North Carolina for the Mark Furman tapes in Winston-Salem, and the firm I was with was on the other side of that case. So I was in the courtroom for that. So I watched Cochran and F. Lee Bailey in court, and it was only Cochran arguing. And I knew the judge really well. So we used to shoot together a lot. And I wasn't arguing or doing anything on the case other than watching it. But Cochran was really good, really good. The judge found against him, but the Court of Appeals reversed that and supported him. But if back in those days, if you were in Winston-Salem and a lawyer came from Charlotte, they might as well have come from New York City. So I think that could be like that everywhere. You got an edge if you're local in terms of credibility. I mean, if the judge has seen you tell the truth 100 times in a row, and some dispute comes up in court where credibility of the attorneys matter, that's an edge, right? They know that the judge knows you won't bamboozle them. All right. So let's see. Was I involved in the witch trials? Nope. I didn't go quite back that far, but pretty far back. All right, so that's all the stuff I think on the Sarah Boone thing. And then in theory, hypothetically, I'll show this Daryl Brooks hearing on Monday because I can't look away from it. It's killing me to do it, but I will endeavor to do it. And I'll also come back on Sarah's stuff and go through how the attorney switched through, because the natural inclination, because what she did was so bad and she's so annoying, is that she's the reason why each attorney left the case. And I don't think that's true, but I'll show you why I think that. So that is it for all of this. And I really appreciate Steve coming by and giving us some actual expert advice on what's going on. I'm not going to say advice because we don't give legal advice, but perspective on what is happening in the system generally and in the case in particular down there. So that's that for this. And everybody have a good weekend. And thanks. Bye.